the United States Supreme Court to redress and correct the grave injustice and the crime against humanity which is being perpetuated by their decisions in Roe, Doe, and Planned Parenthood versus Casey. The U.S. Supreme Court committed a grave injustice and a crime against humanity in the Dred Scott decision by denying personhood to a class of human beings, which is our fellow Americans who are African Americans. The United States Supreme Court also committed a grave injustice and a crime against humanity by upholding the separate but equal doctrine in Plessy versus Ferguson, which withdrew legal protection from a class of human beings who were persons under the U.S. Constitution, our fellow African Americans. A crime against humanity occurs when a government withdraws legal protection from a class of human beings, resulting in severe deprivation of their rights up to and including death. In Brown versus Board of Education, the U.S. Supreme Court corrected that grave injustice and crime against humanity created in Plessy versus Ferguson by overruling and abolishing a 58-year-old separate but equal doctrine, thus giving equal rights to African Americans. When you look at this, under the doctrine of stare decisis, 3 abortion cases mentioned in the subdivisions above meet the test for when a case should be overturned by the United States Supreme Court because of significant changes in facts or laws, including without limitation the following. The cases have not been accepted by scholars, judges, and the American people, as witnessed by the fact that these cases are still the most intensely controversial cases in American history at the present time. New scientific advances have demonstrated since 1973 that life begins at the moment of conception, which, by the way, our Arkansas Constitution acknowledges that, and that was voted in by the people in Amendment 68. And also, the scientific evidence shows that a child in a woman's womb is a human being. Scientific evidence and personal testimonies document the massive harm that abortion causes to women. Just for the sake of not being able to bring them, I have access to over 4,000 written testimonies that have been introduced in court cases across this land from ladies that have actually had abortions themselves and suffered the trauma that comes additionally after having that procedure. The laws in all 50 states have now changed through safe haven laws to eliminate all burden of child care for women who do not want to care for a child. Your committee just did a wonderful thing a few days ago when you allowed the safe haven law to be upgraded here to include boxes where we could actually receive those children safely. I think Senator Hickey had an amendment to that to make sure that they're properly monitored. Public attitudes favoring adoption have created a culture of adoption in the United States, with many families waiting long periods of time to adopt newborn infants. Before the U.S. Supreme Court decision in Roe v. Wade, Arkansas had already enacted prohibitions on abortions under sections that are quoted here in the findings for you. Arkansas Constitution Amendment 68 states the policy of Arkansas is to protect the life of every unborn child from conception until birth, and that public funds shall not be used to pay for any abortion except to save the life of the mother. Arkansas passed the Arkansas Heartbeat Protection Act. 6 years ago, in this very room, was where the Heartbeat Protection Act started. When we did that and passed that act, it actually obviously had the 12-week ban struck down by federal court. But what was left in place with that was the informed consent provisions. And I've had a discussion with several members about my experience with that. In the state of Arkansas, right now, due to our informed consent provisions, we're saving lives, but we're not saving all lives. And what I'm asking you to do in SB 149 is at the very moment we get authority, we will save lives. I've had a couple people bring up the exception issue. I understand that. These are serious issues. But I will tell you that my own experience has brought me to understand that I can't arbitrarily draw a line. I was in a restaurant in Conway, Arkansas about 2 years ago. I finished with my family, Mr. Chairman, and saw a lady coming across the floor pushing a stroller, hurriedly across the floor. She approached me and my family, and she stated to me that she wanted to meet me and was appreciative that I'd stop for a moment. And I greeted her, and she says, "I want to introduce you to Duncan." I looked down on the stroller, and I see a little boy about 6 months old. He's sucking on a pacifier. Had a little bow tie on. I said, "Well, he's a cute little guy." And then when I looked at her, she caught my eye again. She said, "Sir, he's alive because of your heartbeat bill." With that, I really didn't have words. And it's been a while that I can tell this story and actually get it without choking up a bit. I said, "Ma'am, you'll have to explain it to me." I said, "First of all, it's not my bill. The Arkansas legislature of 2013 passed that bill, and they're the ones that are really responsible. This is a law for the state of Arkansas." She said, "Well, let me explain to you." She said, "I'm the adopted mother. Duncan's mother was raped, and she took the morning after pill. It didn't work. That was Duncan's first survival. She then appeared at the abortion clinic down the road from where we sit here, just 10 or 15 minutes. She was prepping for her abortion. They performed the ultrasound, which the Heartbeat Protection Act does require, and they detected a heartbeat, and they told her of the statistical probability that her baby would actually make it to full term. With that knowledge, she said, "I can't do this," and I put the baby up for adoption. She told me that story. I thanked her for that. It's the first time I'd ever seen someone that told me that. And absolutely, members, what you do here absolutely has changed lives in that particular situation, and has changed lives in other situations. So when you look at the history of what Arkansas has done, we passed Amendment 68. We even passed here, after the heartbeat bill, Senator Jim Hendren ran a bill which changed our fetal homicide law. We used to only recognize it at 12 weeks that there was the infant's life. Now, the infant fetal homicide law in Arkansas recognizes that from the moment of birth, of conception, in a mother's womb.